business is approving the meeting minutes. Has everybody got a chance to look those over?
I'll make a motion.
Motion to approve.
Second.
All in favor?
Aye.
Opposed? Okay. Now, I'd like to, we have a fairly long agenda tonight. Some of this may take some considerable discussion, so I'd like to skip ahead to 8, 9, and 10, because we have some guests here who will otherwise be held up for a while. So 8 is authorizing an agreement with ES&S Systems and Software regarding a high-speed digital ballot scanner for the Board of Elections. I see the commissioners are here.
Yes, Mike, this is a purchase. We're going to obtain a high-speed digital central count tabulator scanner for our absentee ballots. And it's $120,000, but it's fully funded with HAVA grant money. And we've gotten the pre-approval from the state of New York for the purchase, which you have to do if it's more than $5,000. And we've taken a look at the piece of the equipment. It's very, sophisticated, high speed. It's would be very beneficial to the board to acquire this.
Okay. Any questions from any members of the committee? Okay, hearing none, is there a motion? Motion to approve. Second, all in favor?
Aye.
Opposed? Okay, thank you. Okay. 9 is authorizing an agreement with the Capital District Women's Bar Association Legal Project, Inc., the legal project regarding a campus legal assistance for victims grant.
Thank you so much. I appreciate your time. Actually, both of them are fairly related. There's been a lot of effort with the Enough is Enough legislation in addressing violence on campus. And I'd come before you to get MOU signed a while ago, and tonight really is furthering that agenda. So the first one is civil legal services for students who've been assaulted on campus. Right now, there is no opportunity for them to have any sort of assistance with representation. So this is going to allow them the services that they need, as well as partnering with the community to have training and other support services that the victims need as well.
Questions from the committee? These are, we're really addressing both 9 and 10 at the same time, right? The two resolutions.
Oh, and then number 10 then is actually, we were given the contract by New York State. At this time, it's a 2-year contract, but I would believe it will continue as $102,000. And again, it's to dedicate an individual to be our campus coordinator for the sexual violence, domestic violence, dating violence, and stalking on campuses. There are so many campuses in Albany County. We were given quite a large award, and I'm looking to actually be able to be on campus on a daily basis between all the different campuses and really getting in there and working with the students, doing a lot of events, prevention activities, and awareness things.
Oh, okay. All right.
Yes, just a real quick question. I noticed that Albany, Siena, St. Rose, and Sage colleges are on here, Albany College of Pharmacy. How about any of the other schools in the county?
I plan on requesting MOUs from all of them. Those are the ones I currently have MOUs or are currently in conversation with. I plan to approach every single college in Albany. They don't have to accept, but I plan on approaching them and seeking them out, absolutely.
All right, thank you.
Siena's on that list.
Siena's on the list.
Yeah, okay, yeah, because the legal project, they're part of that whole.
Yes,
They're
yes.
on one too, yeah.
Yeah.
Anybody else on either of these? I mean, they're interrelated,
Yes.
right? 10 gives you 9.
Yes.
Opportunity for 9. Okay.
I'll make a motion.
Okay. Second. All in favor?
Aye.
Okay, that's for 9 and 10, the related resolution. We have a motion on 10.
Second.
Second. All in favor?
Aye.
Thank you very much.
Thanks. Okay, so now we'll go back to the beginning of the agenda. Number 1, which is resolution number 72, public hearing on proposed local law B for 2016. Mr. Klein?
Well, speaking of which, this was good timing that we had those first 2 resos first, because it's a really good example of the kind of things that the Crime Victim Center is doing, going beyond, expanding their mission, really improving their mission and tapping into state funding when they can. So the purpose of this public hearing that the local law is bringing up would make the Crime Victim Center a permanent part of the county government by putting it into the charter. There's a couple important reasons for that. One, and I think many of us were here sometime in the last term, I guess 2 terms ago now, where there was an effort to close, privatize, get rid of the Crime Victim Center services, and the legislature stood up and blocked that and said absolutely not. If this is a permanent part of the county charter, that will not happen again. And that was the previous administration. I have no sense this current county executive has been anything but supportive of this department. But you don't know what the future's gonna hold. There's gonna be other county executives. I would love to see this be a permanent part of our government. The practical thing is also that Karen Ziegler has done a tremendous job getting grant funding, increasing grant funding for the department. If they are a permanent part of the government, a permanent thing in the charter, it's gonna be that much harder to get easier, to get grant money because, the grantors will see this is a permanent part. We're not gonna run the risk of making a grant and having the department be gone in 2 years. So I think not only is to send the right message that this is one of the most important departments in our county, it's gonna make it easier for them to do their job in getting grant money. So I would love to see this public hearing resolution go forward and hopefully move the local law forward as soon as possible.
Now, I see that it has a public hearing date of February 23rd, but we're going to obviously have to change that to March, and I think 29th is the date for the public hearing, that's the public hearing date.
Yes.
Is that, yeah.
The meeting is 14th.
So, Brian, you want to amend this to change it to March 29th?
Yes.
Okay, all right.
Second.
Can I ask a question?
Sure.
Just clarification, Brian. Going back when it was called rate prices,
Yes.
remember all those years ago? Didn't New York State put into law that counties had to provide rate prices services? At that time, mandated that they did for counties such as ours, as certain populations, whatever. Do you remember that?
I
You know what I
don't.
mean, it makes sense that if it's mandated to provide those services. I seem to remember that back when it was Judy?
Yeah, Judy Condo.
Yeah, right.
It's a
Um,
good question. I mean, the one
It
thing
makes
is.
sense then to
yeah.
do this, you know what I mean? If it's
Yeah.
also the law that we require these services.
And I think we're kind of expanding the
We
crime
expand-
victims
Yeah, yeah.
mission is going
Yes,
way
we
beyond
did.
that. I'm not sure, because I'm not, and it's funny, because I think Judy was from
Yeah,
Rensselaer.
she
I'm not
was.
sure Rensselaer County has an equivalent crime victim center.
Yes, they do.
Do they have rape crisis or crime victims?
They,
both?
it's crime victim sexual assault.
Okay.
Yeah, I work with them.
Yeah, okay.
Mostly kids, so.
Yeah.
Just curious if you knew that.
I didn't.
Okay.
Anybody else have any questions, comments?
Not a member of the committee, I'm here representing Mr. Mendon tonight, but just as a curiosity on this, as a new guy, does this require a vote for the charter, or a change to the charter? As a charter
You mean go
amendment?
on,
This one here.
right,
to
you're
add-
talking about a referendum?
Yes.
No, because, I don't believe so, because it doesn't affect the power or duty of an elected official. That's, anything that requires, affects the power or duty of an elected official would have to be subject to a referendum.
So you can amend the charter without a referendum?
Some
Parts of
things.
it, yeah.
There has been 2 or 3 local laws that have changed the charter in the last 10, 15 years.
Well, I was just wondering if you pass this, whether it would be impacted if there were any other charter-related amendments that were to happen later in the year.
Right, that's something that the last legislature dealt with exhaustively, it seems. And part of the problem that we faced were, we had a proposed entirely new charter. And the opinions, the legal opinions we got at the time from the Association of Counties, from all our attorneys, were that if we had an entirely new charter, the whole thing would have to go up for a yes or no vote by the public. However, if you do discrete charter amendments, some would have to go up for a referendum if they affect the power or duty of an elected official, and others wouldn't. So this is a discrete charter amendment, and so I think the short answer is it does not need to be approved by the
I
public.
think your point's well made, because this was part of the charter proposal last year. It was obviously one of the quieter parts of that, and I think one of the reasons to want to do it as a freestanding is I don't want it to be tied up into other issues again. I think it's important enough to stand on its own.
So if this were passed and adopted by the legislature as a local law, it would stand by itself?
Yes.
And it would not need there wouldn't be 2 or maybe 3 charter votes?
Yeah, and actually, right.
subject to a permissive referendum. So somebody would have to actually go out and get signatures and vote.
Yeah, I'm not sure if it would be subject to a permissive referendum, but I
Might
can't
be.
imagine anybody would do that.
Not
But that's an
not to
academic
add such a good
discussion.
thing to the
Not
to the
for
charter,
this.
you wouldn't think, but, okay. Thank you for the education, I appreciate
Right,
it.
so, you know, if we do it, if the legislature adopts this as a charter amendment by local law, even if down the road, this legislature put up like a whole new charter, and if it went down again, well, this would then be in place because it would be part of the current charter.
That's what you're trying to accomplish.
Yes.
Yeah. Okay, so is there oh, you made the motion to approve it as amended to March 29th? Second. All in favor?
Aye.
Opposed? Now, related to this, item 7, Brian, is actually the proposed charter amendment. We'll have to, you want to table that, request a sponsor at this point?
I would assume so. It's usually better to do unless the committee feels otherwise. I kind of prefer to post public hearing.
Okay.
I don't
all right.
expect we'll have a lot of negative comments in the hearing on it, but I still think it's probably good to the committee to hear it.
Okay, table
Post
and
the
request a sponsor for that one. Okay, number 2, preventing the hiring of former county legislators and the family members of current and former county legislators by the county of Albany. This is Mr. Mayo's resolution, but he told me that he's, I guess, away on vacation this month, and he asked Mr. Higgins to present this.
That's correct. Thank you, Mr. Chairman. I went on as a co-sponsor in, briefly, just on the resolution. I think the concept is pretty self-explanatory. The idea here is for a member of the legislature or former member of the legislature, after leaving employment for one reason or another, that it will prohibit their hiring for 4 years, or the hiring of one of their family members. There are several issues that we've been discussing about, it's a very, very restrictive resolution. 4 years versus 1 year or 2 years, it's even more restrictive at the state level, as well as what the definition of a family member is. Are we talking about a nuclear family? Are we talking about an extended family? So those are two of the issues that we're gonna start discussing, I think, in the next couple of weeks about how we can change that language, but Mr. Mayo wanted to get this in, I think, as soon as possible. So this is the original draft, but I would anticipate some changes from the sponsor. I have some questions for him, but we've been discussing those changes that I brought up. And if other members of the committee have changes, I'm sure he'd be willing to entertain them.
Okay, so you think you and Mr. Mayo are looking to
The concept,
change this?
yeah, I
down
mean, the
the road?
concept itself, I think, is embodied in the resolution.
Okay, so you're not looking for a vote on this tonight, or are you?
No, not
No.
tonight, we'll table it.
Okay.
I mean,
So
I'm
you wanna just-
interested,
You start discussion.
exactly, I'm interested, I think myself and David, we're interested in hearing what other members have to say about it, whether it's a good idea, a bad idea, whether they're willing to support it. If so, how much of a restrictive measure? Like I said, 4 years is, I think, incredibly restrictive. But that's what he wanted to start the conversation at. So I'd be interested to get some feedback from members of the committee about the actual concept itself, if anybody has any.
We'll open it up for comments. Anybody from the committee? Brian? You look like-
No, I think I do have some concerns on certainly on the length of it, but somewhat on the concept. It's a little different than the idea of a revolving door. I mean, the revolving door concept is usually electeds not going into private service and basically economically benefiting from their public service experience. This seems a little different in that, electeds would not be able to come in the government later. It's a similar economic type of argument, but it doesn't seem to be quite the same. It seems like a legislator might be in somewhat of a unique position to serve somewhere in the government effectively. I think it would be comparable to state legislators not being able to go to an executive department, which seems to be happening all the time up there. So I'm a little uncertain on this one. I understand the point of it, but I'm not sure. I'm not sure it's the best idea.
Yeah.
Chris, you said that it's more restrictive than what the state has. Does the state have, I know the state has a restriction on if someone leaves, say, the state legislature, I think there's, a 2-year
2
period
years.
that they can't lobby.
Correct.
But could they go to state employment? Is there any limit on their
Well,
being employed by the
If you're a
state?
state legislator, I think you're still banned for 2 years from going to lobby.
To lobby, yeah, but I'm talking about employment like this. This is a
Oh, I'd have
limitation
to-
on
I don't
employment.
know.
There's no,
That's a good
so far
question.
as you know, there's no
I
limitation on
don't
employment.
think so.
But they changed the law in the last 6 years, because as to Brian's point, there have been state legislators that have went to work for the governor, not to say in the governor's office, but for the state of New York in various positions. So, and I guess is this, taking somebody's right away? I know that we're a 39-member board, but if somebody, if there's a position that somebody on the legislature, whether it's current, past, or future, that could wind up advocating or being an asset to the residents of Albany County in certain positions, it seems that you're almost limiting them
Yeah.
on what
No.
they can do and what they can't do.
I understand. I think the concern is, for example, in this year's budget, where we added positions into the
Well, that was the
county
perception of what everybody had.
But then it happened, right? Then it
What
happened,
happened?
right? Didn't Mr. Kochfeld get a job working for the county after we created a new position?
Well,
I
is-
think that's the concern that David had.
That was a new position. As a matter of fact, that position was cut in half.
But
My
it's still a new position.
My recollection of that, Chris, is that I thought, and maybe my recollection is wrong, but I thought that the sheriff said that position had been in his budget previously,
And-
and that he had not filled it. But I don't think it was a new position, if that's I thought that's what you just
Well,
said.
I mean, certainly, look, that's something we can discuss. Maybe it gets tweaked to only apply for new positions that are created through the budget process. So I mean,
But
that would be a glaring loophole to me. All of a sudden, there's an opening, and then somebody, for one reason or another, is in county service, and then
Right. Well,
they
that could be-
take the vote on the budget to create the position,
Right.
and then they end up in the position. I think that's the perception that David is concerned about. Now, certainly he's not here, I don't want to speak for him, but
You're right.
when he described it to me, that's kind of what he's trying to get at.
Do you think this is something that could be done by resolution, or is this something that we'd have to do by local law? I mean, you're confident that this could be done by resolution?
He put it in as a resolution, I mean, I don't,
I know you're presenting it for him, so
Yeah,
I guess
I mean, I don't-
have
I
to
don't-
put you on the hot seat.
I don't know why you'd have to do it as a local law.
Well, actually, as a result of my friend and colleague, Mr. Krause's resolution that is coming a little bit later concerning the charter, I spent my weekend having a lot of fun reviewing the commission's proposed charter. And the commission's proposed charter has a section entitled Members of County Legislature Filling Vacancies in County Service. And that caused me to look at our current charter, and we have section 2603 of the county charter, which specifically authorizes a legislator to be appointed to any position in the county so long as they resign prior to appointment.
No, so you
So
think
this
the
would be
charter on the-
contrary to the charter. And I think, unlike the earlier charter amendment that we discussed, that probably wouldn't require a referendum, this seems to me it probably affects the power or duty of an elected official. For example, we'd be telling the district attorney there'd be limits on his ability to appoint people, or other elected officials. So this is probably something that would take a charter amendment and have to be passed at a a referendum.
Local law.
Yeah.
And then
So, I mean, I don't know if you want to take a look at that.
Yeah, I will.
I was
I
going to
didn't-
call
I wasn't
Mr. Mayo, and
aware,
then
and
he
I'll
was
let him
away
know.
on vacation. I just really kind of noticed that
Yeah,
recently.
that's
in
interesting point.
Preparing for the, this also, I mean, it would affect, potentially affect the employment rights of people who were, you gave an example of one person, because this would have retroactive effect.
Yeah, I looked into that,
Um,
that's constitutional,
that is-
retroactivity of it.
That's constitutional.
Yeah, I have some legal research on that
the-
piece of it.
The retroactivity of.
Whether or not, I mean, even I question whether or not we should, as a matter of public policy, make it retro like that. But like, he wrote it, I went on conceptual.
So anyway, this is just like a little bit of brief research that, I just happened to
Yeah,
run into looking at this other thing. So I'm wondering, maybe we ought to send this whole thing to the county attorney
Sure.
for an opinion regarding.
yeah, I mean, if it has to be
legality of
changed to a
the
local law, I totally understand.
Um,
Ultimately, it's his bill, so he has to decide the fate. You know.
Right, and so, okay, so do we need a motion to send this to the county?
You just have to make the
Okay, I'm going to make a request then
Sure.
that the county attorney
I think that's a good
review
idea.
this and give us his opinion, and then you're tabling this at the request of sponsor.
Yeah, I mean, if I'm allowed to do that on his behalf, I
Well, I
would.
think, yeah.
Who is the county attorney now? Do we have one?
It's Mr. Lynch.
Mr. Lynch.
His first name.
Oh, that's right.
You just voted for us.
Just voted for it.
Not even,
Last meeting.
Remember we all stood up and
Lucky Mr. Lynch.
Yeah, really.
Right out of the gate. It's something that might be a little thorny. Okay, so we'll mark this as tabled at the request of sponsor, and we'll send it to the county attorney for an opinion. All right. Next.
And I will let him know.
Mr. Mayo?
Yes.
Yes,
When
okay.
he's back in the country.
Number 3, amending the Albany County Legislative Rules of Order. And this is yours, again, Chris, I think 3 and 5, or what is it, 3 and 6 are related, right? You've got a couple of different amendments
I
to
think
the
3
Legislative
is
Rules of
mine.
Order.
And 6 is Rich Mendix, and I'm a co-sponsor.
Oh, I see, okay, yeah, all right. So 3 is yours. All right, so we'll just deal with 3 then.
Sure.
Again, I think it's a pretty basic resolution to change the legislative rules of order. I think to make them more small d democratic, you know, the way they're currently written and interpreted, chairman on unilateral authority on his or her very own discretion can send bills back to committee. This happened to me personally last year with one of my resolutions. Nobody got a say in it, it just went back. I thought it was terrible. It spent months in committee, I worked on it, came out of committee with a positive recommendation out of the blue. Former chairman sent it back without so much of a peep, and I think that's really unfortunate, not fair. I think if we're gonna do that, then we should take votes of the whole body, and see how the rest of the membership feels. So that's what this would, this rules change would accomplish. It would take that language out and add in language that would allow the chairperson to send on first impression everything that's on agenda to committee, and then after a local law is heard, if there's a public hearing, to send that back to committee also. If, you know, there's changes that the public requests, and we're gonna work on it further in committee for those rare situations where the local law is out and the public hearing is happening either simultaneously or kind of around the same time.
So this would change it. Currently, the chairman can send something to committee, and if it comes back, could send it to a different committee. And that's what you want to avoid, is having it go back to a different committee.
I think any committee, really, because we're in the practice now of sending bills upon initial introduction of multiple committees. For example, the Mayo bill is also in personnel, so that was referred upon its introduction to 2 separate committees. So that's happening right now. What I'm trying to avoid is once the bill makes it out of law or makes it out of personnel, and it's on the full agenda for an actual up or down vote, that at that point it can't just be sent back unilaterally. If it's going to be sent back, it would have to be sent back upon motion in a vote. And that language that's struck out is what's in the current rules there, so you can see how the current rule is written.
And maybe some discussion of item 6 would be in order at this point, because I
Yes.
think
6 is
that's
not mine, but.
somewhat related, because that would, I think, allow a challenge to a
Right.
ruling by the chair to send something to committee.
Well, I think it's broader than that. It is more conceptual than just committee. If someone were to challenge the chair on a point of order or a decision, and the chair makes a ruling, if there should not be a voice vote where the chair determines whether he wins or she wins or loses. And that if there is a potential dispute, it would be subject to a roll call, and 20 votes you have would be the decision of the body. And I understand that there are some instances where this has happened in the past. And Mr. Mendick, back in 2014, actually passed a law or a resolution in which any decision or rule of the chair the members of the body were the final determiners of fact. But when he raised this point of order, he was ignored, and the proceeding went on. And when you talk about undemocratic little d, what could be, if there's a ruling of the chair, if it's contested, it could be subject to a roll call vote.
Okay, so in any event, and I see, Chris, that you're on this one, at least,
Yes,
so.
I went on it.
Do you feel I did justice to Rich's?
You know, and I would just say, as far as both of these concerned, you know, my full-time position is attorney in the Senate, and, you know, this is a power that's really pretty much unprecedented, where things can just unilaterally go back when the member can't even challenge something. And I know this is not something that's in the Senate Rules of Order, or in the Assembly Rules of Order,
Right.
you know, because.
It always seems in the Senate and the Assembly, nothing ever gets out of committee. At least we have rules
Sure.
that things get out of committee.
You know,
right? Everything sits there in committee forever.
Sure.
Doesn't it? I mean, that's my impression, just as a member.
But there's always, on a contested issue, there's always a show of hands, or, you know, a long.
Right.
A
So
way
that
for
you
the
can see how
members to
people are
express themselves and be counted affirmatively.
My point on 3 is, Sean, do you want to pipe in there? I saw you raise your hand.
Well, I don't want to interrupt you.
Yeah.
I'll wait.
Well, my point with 3 is, it just completely defeats the purpose. You know, you work on something for 2, 3, 4, 5, 6 months in committee, you amend it, you change it based on the committee process, and then it gets out, and, you know, for one reason or another, boom, it's just sent right back. And I never understood why we did that. It really, really bothers me.
I would like to speak on behalf of the chair. First of all, I would never unilaterally, I can't even say it, Chris, send something back to committee without informing you why it's being done. And sometimes things come up that are procedural or legal where it needs to go back to committee. And I don't want to lose the right to exercise that option. But as far as just sending it back just because I feel like it, that'll never happen, right? I'll give you my word on that as a professional. And second of all, I think we noticed in the first few months here that when we have voice votes and there is any nay that I hear, I automatically call for a roll call, and that will remain happening. We've already, Mr. Camiso introduced a resolution back in December that any budget vote would require a roll call. Now, we kind of, I believe the legislature kind of decided last meeting that we would be okay with if there's, that we would just do a voice vote unless we heard somebody that was in opposition, then we'd go to a long roll call. I would continue to do that. But I would hope that you'd give me an opportunity to prove myself to you that I'm a man of my word, and that I promise that I will do that. Chris, I'll never, Mr. Higgins, I should say, we're going to be now. Mr. Higgins, I will never unilaterally throw something back to committee. I will give you a reason for doing it. You might not like the reason, but I think the chairman reserves the right that if there's a legal reason or a procedural reason, he should have that option to have further review before we send it to the floor for a vote. That doesn't mean doing it for 12 months straight. That means in order to get the right answer on something. So I would hope you consider that before you vote on this tonight. Thank you.
It seems to me, Chris, just.
Sure, can I just
that-
respond to that, though?
Sure.
I can appreciate what you're saying, Sean, and I think you deserve a clean slate, because this is a new 4-year term, and it's a new chairman.
Actually, it's a 2-year term.
New
I'll take
2-year
4
term.
if you want to give it to me.
And you deserve the benefit of the doubt. I would only simply say, in response to that, what if I, as the member, want, and you could have your opinion as the chair and say, no, there's a procedural issue, what if I respectfully disagreed, and I wanted a full and fair airing
We
of
may
the entire
disagree.
body on that, you know?
We may disagree.
That's-
But there's also been instances too, where we have the 60-day rule on issues that come to committee. The legislators introduce things, and then they never show up to committee, and they sit there for months upon months. And that's not the fault of any chair, that's the fault of the sponsor who has to act on it. And we have to take that into consideration too, before we go with a blanket policy on that.
Yeah, I was going to make the point, Chris, it seems to me that Mr. Bergdorf's resolution, I don't know that we'll get to that.
6?
Yeah, 6, that's Mr. Mendix, I guess, Mr. Bergdorf's here, makes some sense to me, because I think that there should always be a mechanism to challenge, a ruling of the chair. Now, I would suggest, when we get to it, maybe some modification to this, but.
Well, 6 would supersede.
Well, that's what I'm saying. If we
3,
maybe go
essentially.
to 6, because it seems to me to say that something could never be sent back to a second committee, perhaps is a little bit short-sighted, because let's say you're talking about something that, it gets vetted through the process, and all of it, maybe it was in the Audit and Finance Committee, and an unexpected legal issue comes up. So now it looks like this really should go to law. There ought to be a mechanism for being able to do that. I do, though, think that, if the legislature, has an issue with that referral, then there should be a mechanism for a vote of the full body on the referral. And that would be number 6. So I don't know if you want to hold on to number 3 until we discuss number 6, if you want to jump ahead to number 6, or how do you want to?
6, I'm happy to table this for now, and we can move over to 6. Personally, my feeling is I think we should create a committee to look at all the rules, because I think they're terribly antiquated, I think they should be updated. Each individual rule, I think there's lots of different things that really need work here, like we did with the charter.
Sounds like you'd be the man to head up.
I would love to do it, I love this stuff.
All right, so we'll table number 3 for the time being, and why don't we, since we're on this subject, why don't we go to number 6?
Can I just respond to Sean? I'm new here. I've been impressed with the way that the orderly flow of the legislature has proceeded to date. And maybe some of the stories of yesteryear and urban legends are times forgotten. But it does not hurt to have something like this in our rules, should the benevolence of and the understanding of the current chair. People change, legislators change, everything changes over time. But I think that this concept of when someone makes a decision, being the person to decide aye or nay whether a voice vote works, is probably a structural democracy for the body. And, I'd like to consider us moving forward with that, not as an indictment of anything, but of a recognition that someday it may need to be utilized.
Just speaking for myself, I don't have any issue with that. I think it should be a roll call vote. It shouldn't be the call of the person whose decision is being challenged. It should be a roll call vote. I also think, myself, it should be something more than a simple majority, though, because I think in respect for the position of chair, I don't think you want your chair being overruled by a simple majority. I think more along the line of what it would take to override a veto, so to speak, would be more appropriate, in my opinion. So our veto overrides, or either, depending on the type, it's either 2/3 or 60%. I could personally live with 60%.
Are we talking about 3 or 6?
Well, we're talking about 6, you tabled
6.
Yeah.
3, right? We're talking about 6. So I don't know how other people on the committee feel about that.
See, I'm doing what I would call one of those gazintas in my head.
Right.
51% is 20. What if
60% is 24, 2/3 is 26. I just myself, I think to retain, some authority in the position of chair and some decorum. You know, there should be some higher threshold than a simple majority, but still a mechanism to challenge, you know, the referral, and I think regardless of who the chair is.
Do we
or
know
the
what
configuration.
Robert's Rules of Order does on something like this?
I don't.
I didn't see that there, Pat.
Robert's rules is, what, 800 pages long.
Yeah, I gotta
It's
figure out
hard
what
to-
it is.
yeah. Brian, did you have something?
I mean, if the idea is to make sure that something has strong support, still goes forward without the unilateral decision of the chair, 60% does that. So I think that might make sense.
I mean, that might be a compromise that everybody could live with. It creates a clear mechanism. It provides for a roll call vote, so the chair isn't deciding by his or her ear that whether or not he or she is overridden.
So it's
And,
a
you
difference
know,
between 20 and 24.
It gives us some threshold that's relevant to other, you know, veto overrides, you know.
I mean, I don't, personally, I don't support that. I think
Too many sponsors.
20 is 20, you know, if you had an issue, for example, like the construction of Times Union Center, that's something that under the current rules, if the chairman didn't like it, he could constantly just send it back to committee. Send it back to committee, maybe we wouldn't have a TU center, you know? Because that was a vote that was determined by one vote, you know?
Right, well,
I mean, even if you had the will of somebody, I mean, that would effectively obstruct the democracy of things that would otherwise pass. And just, you know, just burying it. So I think the, as it's written, I think it's okay. I mean, I support it as written.
Anybody else? Pat, did you have something?
I think
I mean, I would hope we just wouldn't ever have to use this.
Yeah.
everything else is like, as you say, 60% or 2/3 to override or to do anything. As a matter of fact, to suspend the rules, it's 2/3. So we're
Well,
lowering the threshold right now if you go
But
to
to,
60%.
but to elect a chair, it's 20.
Right.
So the basic power of the chair is derived from a vote of 20 people. So it would seem to me, I know there are a number of, that, you know, I'm not sure that the opinion of the chair should be held to a higher standard. I mean, it's like,
That's why you liked them.
well,
Well, you know, Mr.
once again, this comes down to something where an opinion is contested, and it may be on an issue as Chris and Brian have said, decided by one vote or 2 votes, where that opinion as to whether or not something is in order is a basic building block of the organization of the legislature.
I think currently, to challenge an assignment of a referral to committee, the way that it would be done under our rules, before your amendment,
Okay.
would be to take a motion to suspend the rules.
That's what you'd have to do.
And that's what you have to do, and under our rules, it's a 2/3 vote to suspend the rules. So, I think if we
Well, if there's one thing.
streamline this to say, you don't have to suspend the rules, we're gonna put it right in the rules that you can challenge the referral to,
I'm not suggesting that it's just the referral. This is broader. This is any challenge of the chair. Okay? This is, could be any point of order. It could be a budget situation.
60%.
Yeah, that's good.
Right, well, we could do it 60, I'm just thinking, you know, in terms of the procedures here, when you have an elected chair, currently, the rules would be to suspend the rules, it takes a 2/3 vote. I think if we did away with that and said, hey, by a 60% vote, we don't have to suspend the rules, we're just gonna put it right in the rules, that it would be a 60% vote to challenge a ruling of the chair. And make sure that it's a roll call vote. I think that's a very good point. It should always be a roll call vote on something like that.
Well,
That's just my
let
opinion.
me
I mean,
make a
it's-
suggestion that might move us forward.
Yeah.
I'll put my notes. 60% tends to be consensus. Rich, when you're back next, let's table it, and Rich, when you're back next month, if you'd like to put it before the committee again and expand upon the arguments that it should be a number other than 60%, it should be 51%.
Yeah, I mean, the idea of tying in with the 24, the 26, I mean, those numbers for votes are specific to triggers in the county charter for purposes of overriding a veto or passing a bond measure, not necessarily whether or not something that's embedded in the rules, you know, should go one way or another. You know what I mean? So I don't see a special. I mean, there's a special significance attributed to those numbers as they pertain to what the charter requires us to do, to affirm or, you know, vote down a certain
Right, it
action.
may be akin to ending debate in the US Senate.
So,
I mean, there,
yeah,
you know, there
that's a
there are
check.
some reasons for doing it.
Well,
but-
why don't we table it for now? And I think with an agreement that it would be on the agenda next
It'll
month.
always be on the agenda.
Okay. And perhaps Pat Narnis can discuss what Robert's Rules of Order actually say on this subject when you,
I don't think we have to go to Robert's Rules of Order, because currently, Rule 27 says that it shall be decided by a majority of the members present.
oh, okay.
So,
Oh, it's in
anything,
there.
But that hasn't been applied to referrals to committee, right?
it would be applied to anything.
Anything.
Anytime there's a
Anything.
challenge of the chair. So if you're cutting out a specific issue,
Oh, well, we're not
specific
gonna
area-
change
Let me
that.
respond.
Okay, go ahead.
The
Thank
ruling
you
of the
for reading
county
that.
attorney and myself were that the specific thing with referral to chair was a specific grant of authority, separate and distinct from that. Therefore, it was why he had the ability to do what the chair had the ability to refer. What we're saying now is, at least what I think Mr. Mackey is saying, is the reason he's focusing on that is because that's the one that you couldn't refer, couldn't challenge before. And
Well,
I mean, you
that's,
could-
so that's a
Specific grant.
modification of the proposal number 6 to essentially cut out an exception, or to address the issue,
Yeah.
which I'll have to dig the memos out. I don't remember.
Okay,
Yeah,
my
essentially
retro-
what you're
yeah,
saying,
yeah.
what you're saying is that by going to 60, we're actually increasing some of these things.
The standard, you're increasing the amount of
For
votes
some,
and
necessary.
you're saying.
But on the
okay,
one
okay.
issue, you're getting rid of the unilateral authority and making it 60%.
Right.
That's what we're focusing on.
You're talking about this thing from December?
What,
What you're talking about, you and the county attorney arriving at some sort of a decision on, what does that refer? I don't remember that.
it was we determined that in the rules, there's a specific grant of the authority to refer to committee, which is separate and distinct from that Rule 27 or whatever. Therefore, that grant wasn't challenging.
Yeah, my recollection was that rulings of the chair would be subject to
Versus
challenge.
referrals. You're saying
Versus
ruling versus-
referral by the chair, and the only way to challenge a referral by the chair is to suspend the rules. And that's been the opinion that we got from the county attorney, I believe, and that's been how this has been handled. So maybe I misread it. I thought the purpose of this was to address the referral.
No.
Okay.
No. This
So-
is just a general question of the chair.
So-
If there is an issue, which the chair rules on,
Right.
which
Yeah.
someone believes it should be, well, the law says it shall be decided by a majority of the members present. All this says is call the roll, so we don't have to rely on an aye or a nay head count by the chair.
Okay, and you
You're
were
not
not
changing
intending
it.
to expand this then to create a method for challenging a referral to committee?
That wasn't the intent, but let me just jump in.
I think
But-
I was trying to do that.
I understand what Mr. Jeffers is speaking of, so we'll address it. We'll be able to, in essence, that wasn't the original intent, but it appears that we'll be able to kill two birds with one stone, so.
Right, so you want to table this
And
at
keep
your
the present
request?
chair happy.
And we'll continue to work on it.
let's, I just, for me as a sponsor, it's certainly not to, if we were to go and modify this language, I would not be supportive of saying we're gonna turn this from 20 to 24.
Yeah, I wasn't even thinking. of
Okay,
that.
I'm
That wasn't
talking
right.
about just in general, the democracy of the body. Question of the chair, voice vote,
So that's a ruling of the
Contest.
chair as
That's
opposed
right.
to a referral by the chair.
a ruling of the chair.
Okay.
Yes.
All right.
That was, I believe, Rich and my intent, and the others who were co-sponsors. I don't,
So you're really talking about, the salient part of that is to just make sure there's a roll call vote
Exactly.
available. I guess I was reading it maybe in conjunction with Chris's thing, and I was thinking.
This is
well,
why
I
I'm
said
getting all
you-
confused, this is
yeah.
why I think we gotta overhaul all of them personally. Getting into these situations.
I would suggest that maybe Arnis and I should discuss it, see if we can reach a mutually agreeable, either or mutually disagreeable, without killing each other.
I think what you're trying to do is different than what I'm trying to do.
I think so too. I
We're
think mine is more generic building block for the operation of the chamber, okay? At least in
And I
my
think
estimation.
Chris's could be addressed maybe by amending the rules with respect to referral to say that a referral could be challenged by, for example, a 60% vote. That's what I would say. You might say 50%, but.
Yeah, but I see
But
what
it
you're
might be a better method than just saying nothing can ever be referred a second time.
Versus this ruling versus referral.
Right. So, but,
I think we're
okay, so
getting there.
tabled at the request of sponsor, and I think that brings us to number 4, which is amending the Albany County Charter by adopting the charter proposal of the Albany County Charter Review Commission. Mr. Crowder.
Mr. Chairman, thank you very much. As you know, this was introduced back in February. We expressed purpose of once again revisiting this issue. We understand that as introduced into resolution, it doesn't have the force that would be required if we deal with the law. And we also understand that there are a number of legal issues that need to be addressed. You and I have discussed it. You've been very willing to work with me on that, and I appreciate that. So, in the interest of time, I would suggest that we table this tonight. Give us an opportunity over the next month to get together and to entertain any other suggestions you might have. So I would make that recommendation.
Okay, so tabled at the request of sponsor.
Thank you.
Thank you. And number 5, transparency requirements for amended resolutions or local laws.
I guess
Mr. Mendick has been busy, and I'll allow Mr.
This one,
Bergdorf to present this.
this one should be a slam dunk. Everyone in the world, every legislative body utilizes a system where you can easily, in reviewing legislation, see what the new language is, what the old language is. And for those of us who, I have written legislation and spent 20 years reviewing thousands and thousands of bills where you can pick it up and it may be a 40-page bill, but you go to the area where the striking is and you go to the area where the italics is and the underlining is, and you can immediately grasp the sum and substance of what the new law is. For those of you who have never drafted a bill, think of it as you're in Word Perfect and you put on the track changes function, because that's exactly what it does for you, is it strikes out everything that you're taking out and highlights everything that you're putting in so that you can very easily see what the content of the proposed legislation is.
I would simply add that if we're gonna be posting all this stuff online in PDF format now, if we're to do this, I would even say let's do it in different colors, like in red and green, like they do in the state legislature. Really,
Well.
make it pop,
Well,
you
I
know?
mean,
You could do that voluntarily, maybe. We don't have.
You're welcome to revise it.
why don't we adopt a Word Perfect color scheme, you know?
On this one resolution, if this does pass tonight, would you go back on your resolution that you changed, or Mr. Mayo's resolution, and do that for the amended
Yeah, oh,
resolution?
absolutely.
Thank
Yeah,
you.
yeah, yeah.
I think we should do it for everything.
No, no,
I'm
not,
And I understand at one point in time, this was discussed, and it was implemented for a time, and then it kind of evolved out of it, and then it was gonna be back again, but
Well, could I address that? One of the things is that, I think that the two offices were using the track changes, but what happens is that obviously there's a lot of legislation that comes in from legislators from the side. So sometimes, whomever's doing the drafting, either the legislator or somebody for him or her may not have been aware of those rules. And the fact that we now have a new legislature with a lot of new members, that this was a timely time just to bring this back and maybe make it a formal resolution so everybody's aware of it.
I just have one question. What we're talking about here is when there's a proposed resolution and a proposed local law, and it goes through various draft versions. Because some places in here, it discusses a proposed resolution, proposed local law, and other places, it discusses resolutions and local laws. And resolutions and local laws, the way I read them, at least technically, they're things that have already been adopted. So you're really talking about in the drafting process before they've been adopted? Because it seems like they've been used interchangeably
Well,
here, and I had a
I
little
think-
difficulty following it for that reason.
I think at least in my mind, going to 20 years in the state legislature, it would follow both from original proposal to amended versions, where you would see the current version. If something was the B version or the C version, you would see what the current strikes and the current adds were. And obviously, if it's a local law and it's all new verbiage, everything's underlined, it's not a big deal. So I would think it would just be a uniform way for us to look at proposals, whether they be new or amendments or updated resolutions.
So, Brian, go ahead.
First of all, I think you're absolutely right. I think it's a good idea. My only question I have is, if you look at D in the resolve clause, if you're amending an existing local law, it seems to say here that the amendments would only, the underlined bracketing would only be of the prior amendment version. If you're amending an existing local law, it would be hard to tell what's the current law. You know what I'm saying? I don't know if that made sense.
Yeah, you're saying
Yeah.
that going from a B you really doesn't need to see going from a B version to a C version. You want to
Right.
see with the C version how it compares to the existing statute.
Right, yes.
That would certainly be my intent.
Yeah,
And if, council could work that language out, that would be wonderful.
I think it makes sense, because this is kind of saying that the B and C, the amendments would be shown from B to C,
Yeah.
then you wouldn't really know what the existing law is or what the
No,
A is.
I think when you get to the point where you've got multiple amendments, you're really focused on the current amendment and how it affects the existing body of law.
Agreed.
Okay, does anybody else have any input on this? I mean, is it understandable? Again, I'll go back to, maybe I'm just not reading it correctly, but I wasn't 100% clear as to whether this imposes these underlining, et cetera, requirements only when you're in the drafting stage of a proposed resolution and a proposed local law. Do you see what I mean? Somebody introduces local law, proposed local law A.
Right.
So you have an initial version, and then you have 2 or 3, 4 or 5, adjustments to it before it comes up for a vote.
I
You're
would-
saying all those would be tracked with underlining?
No, the current version would be.
Current change version.
The current change version.
Right.
So when you get to C, you're going to have something that looks like right here on Resolution 81. You're going to, if this were the C version, you're going to have a strikeout in the new language, and that's what we would see on an agenda.
So that's how we handle all proposed local laws and all proposed resolutions. So they're initially introduced, and then if there are
Well,
changes before
on the
they're
initial
adopted.
introduction, you would be able to see what's new, what the existing law is, because any law in state government, on your original bill, you show new language, deleted language. And then, as that went through iterations, I would hope that they would be, if this committee decided it was gonna go to make a set of amendments that were gonna be reviewed next month, you would see what amendment, you would be able to track what was taken out and what was put in. And then ultimately, upon that vote, that's the way it goes to the floor, and it appears as in bill copy, or in resolution of local law. Is that?
Okay.
This is,
I mean, I like the concept, I
Yeah.
just was a little bit confused as to maybe its application, but that's okay. I can be confused. All right, so, does anybody want to make a motion?
Well, I can't, I'm not.
I mean, everybody sort of understands what we're talking about, right? I don't wanna,
I think so.
Yeah.
okay.
I think I-
Yeah, then I,
Question, when somebody proposes entirely new legislation, it's gonna come out as new, and then we're gonna sit and talk about it and change it, and that's when you're gonna strike
it
it.
can be underlined.
No, the whole
And
thing
all
would be
the-
underlined.
It'll all be underlined,
Because
because
it's
it's
all new.
totally new.
Yep.
Oh, no.
And then as it goes through committees and meetings and different things, and it gets changed and that, then we're gonna start marking it up.
Marking.
So it's for, and that's the same for as, you're changing, amendment that's already on the books?
If it's on the books, you would bracket
Oh.
out what the old law is. I mean, look at, you can, if you look at 3, Patty, I mean, that's a pretty good example of what he wants to accomplish, I think. Right,
Yeah.
instead of a strike through,
I was just confused too when I read it.
it would literally be a bracket around what's.
Believe me, it
Existing.
becomes so easy over time that you pick up a 4-page or a 5-page thing, and you can immediately scan and see what the intent is, what the changes, what the operative language is. You can focus on it, and it becomes second nature.
So, just so that maybe I'm clear then, if somebody introduces a local law that's amending a law that's on the books, I think I get like the strikeouts and the brackets and all that stuff. If you're just proposing a new local law that doesn't have anything to do with a law that we have on the books, just a brand-new local law, then this wouldn't apply, right? It's just a brand-new local law. It's not amending anything, it's just a proposed new local law.
I don't think it would apply there. I mean, obviously, as it went from, if it was all new text, there's no change. Obviously, it would be incumbent upon the sponsor to be able to come back and talk to everybody and say, pursuant to our conversations, I did this, I did
It would be
that,
underlined.
I did this.
Well,
It wouldn't,
Yeah.
I mean,
if
you
it's
would-
all new, if it's all
everybody would
new
understand what
stuff.
the hell it is.
Yeah.
We much more frequently, at least in my experience here, encounter entirely new local laws that don't change anything from the past.
Well,
you know,
that would be, then it would be
I
much
mean, it's-
simpler to implement.
Right. So that'd be simple. So, yeah, I think that that answers my question, and I think, Patty, you had the same
Yeah, I
question
mean, I'm
did.
just saying, when I first read it,
Yeah,
I was just confused about what you were talking about, whether it's pending resolutions or new ones crafted as you just described, or things that are all existing.
was everybody kind of, right?
I don't want to drag sign further. Does wouldn't this just be for local laws and not resos? Because resos are, not necessarily part of the code. It's, approving a contract or approving a grant app or something.
I think
No, but in this one, it could be a resolution that amends rule number 23, and you have the strikeouts here, and you would want to have that.
So when they're amending a budget, so how would that work?
you would bracket out whatever the old numbers are, and you would underline whatever the new
It's
number is.
it's a new budget.
No, but when you do
a
amendments to
resolution
the
to
budget.
to amend
Right,
the
yeah,
budget.
yeah, yes.
You do the same thing.
During the year, yeah.
Yeah,
Okay.
do the same thing.
Okay, well, James, maybe we'll find out when we get to work with it,
Motion to move.
Okay, we have a motion, second, all in favor?
What's the motion?
Opposed? To approve it.
On behalf of Mr. Mendick, I thank you.
Could I suggest, because I know that the code is being worked on, as I understand it, and it's my understanding that there could be referrals to the code of resolutions, which typically the code would just have local laws in it. But this might be one of those resolutions that might find a good place in the code as people flip through it and become familiar with it. But it also might be a good place because, as you just indicated, as we work with this particular resolution, we might want to adjust it a little bit to clarify for other people. You know, when people read it, maybe people read it differently. But this might be one of those that, as it gets through the process, might be a good one to throw into the code.
Well, I know in the failed proposed charter, one thing that the legislature added to what the commission proposed was that local laws would all be part of the county code, and any resolutions designated for that purpose by either the legislature or the county executive, because on occasion we'll pass what I would call a substantive resolution,
Yeah.
maybe having to do with bidding requirements or various things that nobody really knows where they are, where I think we passed about 800 resolutions here, probably 798 of them would not come under, that category, but the other two we should have in a code somewhere because, and this would be one of those. So you're off to an early start on a couple of resolutions. But that hasn't been adopted.
No, what we're going through, and we're gonna go through, and Brandon is gonna get most of it, go through the last 30 or 40 years and see what resolutions actually would refer to a code or some regulatory authority, and then bring them back to this committee for recommendation included into the code.
Is this what you're doing with the code?
Yes.
Yeah.
We already
Sounds
have,
great.
we've already done the charter. The local laws have been gathered together to a great extent, but they're not all together yet.
Where are they?
And then we're gonna go to the resolutions. That'll be the last part of it. But that is underway. We don't talk about it because we don't want anybody riding us too much on this, because there's plenty of other work that has to be done along the way.
Well, that's a huge job.
It is, but it's also, with the other work here, it's something you can't do every day, unfortunately. But the charter and the local laws should be completed. Isn't it
The charter is,
done?
yeah, the charter should be done soon, and the local law portion itself, we're still in the process of finalizing the last bits before we can give them to general code. And from there, we'll move on to do the rest of the resolutions.
Well done.
You're doing 30 or 40 years of resolution at
We're going
about
back to
800 a year.
We're going back to 67, because that's,
Yeah.
So you're
That was
talking
11 years.
20, 30,000 resolutions you've got to review.
Well, the interesting thing is that during the charter, the original, and I'm not sure if it came up in your committee, but there was a discussion about, well, do you have any other rules? And I think it was the sewer district had a sanitary code that's from, what, the 50s, that they have to abide by. So.
yeah, that's another thing, we'll probably have to ask any department for any regulations they've promulgated to include in there also.
Yeah, that's a good idea.
Yeah.
It's not an easy task, I'll leave it at that.
Motion.
All right, motion to adjourn. All right.
Good luck with that.